Welcome into Phil's Tax Hacks and Other Retirement Facts with CPA and personal financial specialist Phil Putney. Now let's get rolling with today's show. Hey everybody, welcome into Phil's Tax Hacks and Other Retirement Facts. Phil and I are back again to talk beneficiary mistakes, and we've got top five. I don't know if they're top five, but we definitely have five that you want to make sure that you're. And some of these, Phil, are pretty easy to fix, right? So,
but they're all pretty easy to fix if you fix it early.
Okay.
Before the beneficiary elections come into play. I mean, once you're gone.
Yeah.
If these are in there, it is what it is. So.
Yeah, and you can cause your loved ones, your estate, your whatever, unnecessary costs and pains in the tush and all sorts of stuff. And again, they're really easy fixes. So this is a pretty easy, quick podcast this week. I think just to kind of point out some stuff that's very simple to do. Sometimes people feel like the financial world or getting older and all that kind of stuff, it gets really complicated and they kind of feel bogged down by it. So these are just some simple, easy things you can do to correct a few things that won't hopefully spoil your retirement strategy.
Yep. Yeah, if they're caught early and taken care of, all's good.
Well, good. You doing all right?
Doing really good. Yeah, we're warming up here. I don't know what's going on. This is crazy weather, but
it's all over the map. Yeah, at the time we're taping this, it's 70 today, and this weekend it'll be 25. So
yeah, we're supposed to hit 50, and it's like, what? This is February. What's going on?
What are you doing? All right, so let's get into the top five here, or at least the five. I don't know why I keep saying top five, but we got five. Number one, naming minors as beneficiaries. This can certainly add a few wrinkles into some different things for various reasons. Give us a few to think about here, Phil.
Yeah, so the first one, I mean, if you do name a minor and they in fact inherit the money, you passed away and they become a beneficiary, they can't hold the money. So, I mean, it automatically, it's a ticket to probate automatically. Because probate's going to have to be set up for the minor. You have to go through the whole probate process for the minor. There's a guardian ad litem, they're called. I know this because I went through this with my son we had adopted, who was my wife's nephew, and he had inherited some money from his dad or his grandfather. So, yeah, and I mean, it is just a hassle and costly because you got to pay the guardian ad litem, pay the court every year for filing. Okay. Whoever your trustee or executor of the will is, going to have to take care of this, or whoever you've named as the guardian for that minor, is going to have to deal with this, and it's going to cost money, right? So part of the money that you've left to cover or to go to this beneficiary is going to be gone.
Sorry, so bear that in mind. And I'm going to flip these, Phil, because I think this next one leads better into it. The one we had for number two, we'll still get to it. Not naming an alternate or successor beneficiary. This could go in tandem with the minor and help correct that problem, right?
Correct. Yeah. Yes. I mean, if you didn't name an alternate, let's say, and depending on how you name somebody, I mean, it might end up in the minor's hands anyways.
Right.
So I mean, if you've named somebody,
an option, right?
Right. Yeah. If you've named somebody per stirpes or capita, depends on if they've passed, then what their share does. And if it's following their bloodline, so it goes to your grandkids. So you name your son, daughter as a beneficiary.
Right.
And, you set it up per capita where it is the default. Okay. Then it goes to the remainder of the beneficiaries. You disinherit the grandkids, but if you name it per stirpes, and your son or daughter has passed away, it's going to follow.
Oh, thank you for explaining that.
Bloodline.
I was going to ask.
So now you've got to be careful. Yeah. I'm pretty sure I'd have to check the verify, but I'm pretty sure that's how it goes. Per capita means per head count, basically. So whoever's left of the primaries gets it. So I mean, that you got to be really careful of. But ultimately, I mean, you cannot even name a minor as a beneficiary. You've just named your kid. You didn't name a contingent, though.
Right.
And now all of a sudden, their share ends up following their bloodline. If they've got grandkids, well, it goes to their estate. Now it's in probate again.
Gotcha. Okay.
So you've got to be really careful and kind of thinking through how you want this to happen. A lot of times for that scenario, if you have minors, a couple of options. I mean, first is name somebody else, so if you've got a niece, nephew, brothers, I mean, whoever you name it, a relative that you would trust.
Right.
To handle the money for the minor. I mean, that's one option. The challenge with that is there's no legal binding obligation on that individual, right? So if you name your brother, let's say whoever it is,
Sure.
if you pass, it goes to them, and you tell them, hey, my intention is I want this money to go to my grandkids, and they inherit the money. I mean, their name's the beneficiary, and it's theirs, frankly. I mean, from
Yeah.
the court standpoint, it's theirs. So you better really trust that person to follow what you wanted. And
Yeah.
it's now going to create some potential tax problems for them, depending on the type of asset. If it's an IRA, now it's taxable to them.
Right. Right.
So it just makes it really messy. I mean, your better option, if there's minors, is going to be using some kind of a trust, to hold the money.
Yeah. And I want to get to that one in a
So
minute too.
yeah,
Yeah.
yeah. So the mind, I be very careful naming directly a minor as a beneficiary. Just know the wrinkles. If something happens, it's going to be time. It's going to take time because it's going to be in probate until they're 18 and cost money. So
But
do
they're
yourself
easy fixes.
justice
Yeah.
and just walk yourself through it, think it out, have it on the paper, then it's done. You don't have to worry about it and
they're
review it. And
Yeah,
we'll get
and
to
they're
that.
easy
But
fixes. Yeah,
yep.
they're easy fixes. And speaking of the review it, the next one, number 3,
Mhm.
is not coordinating your BDs, beneficiary designations, with your will.
Right.
Every advisor I know has a story of
Oh yeah.
somebody coming in and an ex-spouse is on something somewhere.
Yep.
You know what I mean? And it's like, it doesn't matter what your will says, and it doesn't matter that that your new wife or husband is on there. You left that other person as the BD. That's what the court says. That's who gets
Right.
it.
I was going to say that there's like 3 ways assets can transfer, right? It's according to your will, which is the will is nothing more than direction to the probate court, what you want to have happen. So
Right.
you really don't want that. Can pass by trust, so it flows through a trust, or there's the beneficiary designation, and beneficiary designation is the trump card. So it, like, to your point here, it doesn't matter what all the other documents say. Irrelevant. I mean,
Yep.
if the beneficiary designation doesn't put it in the trust, doesn't matter what the trust says, So I mean, you can leave it to whoever you want in the will, give direction there to the probate court. But if there's a beneficiary designation, that asset's never going to make it to probate. So,
And we tend to think about just insurance policies or something like that, but this goes for other accounts as well, Phil. And it's
yeah,
an easy thing.
there's IRAs, 401ks, I mean, Roth, annuities, insurance. You can have what's called transfer on death, or TODs,
Yeah.
which is basically putting a beneficiary on non-retirement accounts, bank accounts. I mean, just the list goes on. So
Yeah, and
you need to review these on a regular basis. Have a list. Here's my accounts. Here's the beneficiary designations, and make sure they're on there.
Yeah, and I had and I always forget. I think I always forget one of them, but the at least the 4 Ds anyway is a good way to remember to double check these things. If you have a death in the family,
Right.
if you have a disability in the family, if you have a divorce,
Yeah.
and then at least once a decade was the way someone taught me.
Yeah.
Probably
I mean,
sooner, but
yeah, I recommend just reviewing them even annually. Just run through it. Just look at them. Here's what it is. Have a list.
right.
And then you want to periodically, probably not every year, but call the custodians, or make sure you've got like a statement. Not all statements list beneficiaries.
Yeah.
But if nothing else, call the custodian and confirm, because I can't tell you how many times that unfortunately that happens too, right? A custodian changes their computer system or whatever happens on their end, and all of a sudden they don't have the right beneficiary or a beneficiary, period. And I mean, now you better hope that somewhere in your files or the advisor's files, or, in that binder you have that holds all the, wills and trusts, and that you've got that paper signed document that shows there was a beneficiary designation name. It just creates problems, right? So all of this, head it off, have a list. Here's my accounts. Here's the beneficiaries. Review it to make sure nothing's changed. And periodically, not every year, maybe 5 years, call the custodians and, verify who do you have as beneficiary, to make sure that, again, they still have it in their system. So
yeah, and it's an easy update. Doesn't really cost you anything. It's super
correct.
fast. And that way, if you've got, let's say, I don't know, a son-in-law named Brandon on there for your Corvette, you don't want to leave that to him anymore.
That's right. That's right. If they take you off, you can take them off. You can put it back on.
That's right. That's right. We're going to make this a running gag this season to pick on Brandon and the Corvette.
There we go.
All right, so let's go to an estate. So naming your estate as a beneficiary. Obviously, this is probably the more complicated one of the thing.
Yeah.
You talked a little bit about trusts and stuff. So just kind of walk us through a little bit what an estate means and then what happens if you do that.
a state's kind of like the default, right? I mean, you can pass things through the state. I mentioned a will. So a will is really your direction to the probate court as far as how you want things done,
Yeah, I
who
love
you want
that
to get
ticket to
assets,
probate.
whatever it is. But I mean, it doesn't avoid anything. It's just your wishes. If in I mean, the kind of the worst case of all, you don't name a beneficiary. If you look at your custodial documents, in the documents, way deep in there somewhere, it's going to have a default beneficiary designation, which is going to be typically your estate.
Mhm.
So if you didn't name anyone, by default, it's going to end up in your estate
Right.
in probate. And even if you didn't leave a will, now the probate court has a set of laws. Every state has them called the laws of intestacy, meaning, okay, I died, left no direction. So every probate state or every state in their probate law has, here's what happens. Usually it kind of follows bloodline. If you're married, goes to the spouse, those kind of things. So yeah, you don't want things to go to an estate. It's just, it costs money, it costs time.
Yeah.
That you got to pay attorney to open the probate, run it through there. It's all public. I mean, they've got to publish your name, and
And if you've
whoever
got debt,
thinks they've got a claim can make a claim against the
right.
estate. I mean, it's
Yeah.
just this whole process. And, you're talking 6 months is quick. It's, 9 months to a year, depending on what's going on, could be longer,
Yeah.
especially if there's claims issued. And yeah, so it's, you want to avoid it at all cost.
Yeah, that's a good point because if once it goes public, if there's creditors, they're going to come sniffing, and sometimes people say, well, I don't need a trust, I can't afford a trust, I'm not rich enough for a trust or whatever, and we've covered that before, but it's worth mentioning again. It's like,
Yeah.
you don't have to be a Rockefeller to have a trust, right? I mean,
Right.
many people could benefit from a trust, so it's worth asking. It may not be the right fit for you, but
Yeah.
they're not that
And
expensive.
And we should have said this in the beginning. So I'm not an attorney. This isn't legal advice type of scenario, but
Right.
I do enough estate planning discussions, and I know how all this works to work with clients. I can't draft the documents. The reality is, to me, where a trust would fit in too is if you don't trust, right? So you named a beneficiary, you don't really want them to get X amount of money at whatever time, right? So maybe they're still a minor, maybe they're not, maybe they're 18, in their teens in college. So now you can give trustees the orders of this is when and how and what the money is to be used for, and then at certain ages they get it, or you want to protect it. I mean, is another type of scenario. If you're concerned with maybe the marital situation for one of your kids, and you don't want to leave the money to them directly, because if they get divorced, it's part of their marital estate now and could go to the ex-spouse. I mean, there's all these different scenarios that, trust might fit into, but
yeah, that's a good point with that one too, right? Because we sometimes get that when people say, well, should I leave my, I'm getting older, should I leave the house to the kids, to my son, let's say, while I'm still alive? And it's like, nah, there's multiple reasons not to do that. Usually it's around like a long-term care issue or a nursing home. And it's like, well, there's the 5-year look back, but there's also just the simple fact that what if, that marriage fell apart? Now that becomes an asset that your son and his estate, or your son and his ex-spouse, have to go through, right? So there's just lots of reasons.
Yes, I mean, there's a lot of reasons to use a trust. So then the last part of a trust that often gets overlooked, and attorneys don't even get into it, is the tax side of it. And so there's a lot of benefits and reasons to have it, to control the money, to make it, avoid probate, to make it more guided in how and when people get assets. But a trust is one of these really unique vehicles, is that it's what's called a pass-through entity, meaning as long as it makes distributions, then whatever income it had follows through and goes to that beneficiary, which is ultimately what you want to have happen. You don't want the trust to have to retain income, because a trust gets pushed into the top marginal brackets at like 15,000 of income.
Oh, okay.
Versus an individual, you're, married couple over 500. So I mean, the IRS does not like trusts, so I mean, it's don't leave an IRA to the trust unless you have a plan and how that money is going to get out, because, or you have to weigh the pro and con of, okay, is it worth losing 37% of it to taxes, so that I have the control inside the trust and the beneficiary doesn't, get it for whatever reason or goes to pro. So, I mean, there's all these different. Don't forget the tax side, right? That's probably enough to say for here. Have that discussion with your advisor if they know taxes. If not, talk to a CPA. know that before you get in, because you don't want all of a sudden an IRA to get left to a trust. And by the way, if an IRA is the beneficiary, now you got 5 years to take it out. It's not 10 years. I mean, it just changes the whole picture. So
yeah, that's a hefty tax tip right there. So
yeah, don't take it lightly. Don't, attorneys they fund them, or they set them up. They want them to be funded, and absolutely you want it to be used, but know the tax side of it when and if it ends up being funded and used. So,
well, if you're considering a trust or you're thinking about it, then yeah, you need a little team there. Make sure you've got the attorney, make sure you've got the CPA, the financial advisor, right? So all of them, all three of them. And of course, if you're double like Phil, there's two of the three right there. But either way, right, make sure you've got that little team there to make sure it's the right fit for you, because that's a great tax tip. So thanks so much for sharing that one, Phil. All right. Last one, again, another easy one. Just make sure there's no errors on the application. Like, just double check stuff. And also don't forget, people putting stuff in are also human, right?
Yeah.
So, just double check everything. So securities match, addresses, names are spelled correctly. Again, a simple fix, but it can save time and money.
Yeah, and that's to the point of, here's the beneficiary designations I want. Review it on a regular basis. Check the spelling. Check with the custodian to verify they've still got it all on there. The challenge with beneficiary designations, and every custodian is a little different, but usually the common is, who it is, the percentage, the relationship. Might have social and date of birth, but that's probably about it. No contact information most of the time. So I always, in fact, my clients, I provide a list that's a beneficiary list to say, okay, you've named everyone on this list. They'll have their full contact information, and have it in with your wills and your trusts, so that whoever's handling this isn't running around, trying to figure out, okay, how do I get a hold of Aunt Joe and whoever it is that, whoever you've named, just so that they can get the asset to the person that it's entitled to. So
and it's an easy fix, because you might write down the wrong social security number by one number. The person inputting it might swap a 6 for an 8. I mean, it's just little easy things happen. So just double check it.
And I mean, it doesn't mean they're not going to get it. It's just another hiccup and a roadblock. And now they've got to go through and prove who they are, So I mean, it's just, if you have the information on there, make sure it's accurate.
Yeah.
So, and verify what they have.
There you go. So that's just 5 beneficiary mistakes that might make your retirement or or legacy plan a little more messy than it needs to be. Most of these are pretty easy fix. Great tip in there about the trust. So let's just make sure we get that stuff done. And of course, if you need help, as Phil said, you're always going to have that estate attorney brought into it, but certainly have your CPA and your financial advisor help you as well. And if you need some help, that's why Phil's here. Reach out to him at philstaxhacks.com. That's philstaxhacks.com. You can also call him at 248-888-7530. It's 248-888-7530. And with that, we'll catch you next time here on Phil's Tax Hacks and Other Retirement Facts.
Investment advisory services offered through AFS Wealth Management. The content of this program is provided for informational purposes only and is not a solicitation or recommendation of any investment strategy. Investments and/or investment strategies involve risk, including the possible loss of principal. There is no assurance that any investment strategy will achieve its objectives.